Appeal in the matter of Yalcin and Secretary of State for the
Yes, Mr. Malik.
Lords, Lady, I appear for the appellant this morning with Mr. Raman. Miss Mannion appears for the Secretary of State. My Lord, the Vice President asked for the hard copies of the immigration rules as they were at the time of the first year tribunal's decision. Hard copies are now on the bench.
That's very,
ground
very
that
helpful. Can I just get in an apology early to your junior for having been huffy about something which was perfectly all right as far as the practice direction is concerned. It's embarrassing when the Vice President doesn't know what the practice direction says, but the All England is just as good as the weeklies. We're just not so used to seeing it.
Yeah.
Yes, anyway, apology delivered. Carry on.
Lords, Milady, this is a troubling case. It is troubling both from the public interest point of view and the individual point of view. The appellant, as the court knows, has committed serious crimes. He has convictions for possessing a prohibited weapon and possessing firearms without a certificate. He has received a sentence of 5 years and 4 months in custody to run concurrently with a sentence of 8 months in custody for his offending. So from the public interest point of view, he is a perfect candidate for deportation. And no part of my submissions this morning will seek to underplay the seriousness of his offending or the compelling public interest in his deportation. From the individual point of view, his life is closely connected to the lives of his 2 British citizen children. He plays an instrumental role in their upbringing and has a particularly strong relationship with one of them who has acute development needs. His deportation will effectively bring the children's relationship with him to an end, as the children are not expected to relocate to Turkey. The first-tier tribunal on the appellant's appeal held that the circumstances of this case were very compelling, and they outweigh the public interest in his deportation. The upper tribunal on the Secretary of State's appeal set aside the first-tier tribunal's decision and substituted a fresh decision that there are no such very compelling circumstances. So the basic question for this court is whether the first-tier tribunal erred in a point of law in allowing the appellant's appeal. I shall seek to persuade my lords and my lady that the first-tier tribunal, contrary to the upper tribunal's conclusion, made no error of law. Therefore, I shall submit it was not open to the upper tribunal to set aside that decision and substitute a fresh decision dismissing the appeal. Now, this is, I recognize, a very, very familiar territory for the court so far as the law is concerned. So subject to any observations, what I propose to do this morning is to make brief submissions on the law first. Firstly, the law as to the upper tribunal's jurisdiction to set aside the first-tier tribunal's decision, and then the statutory regime concerning deportation of foreign criminals. I will then take the court to the decisions made below and make brief submissions as to the findings of fact. So starting with the law and the upper tribunal's jurisdiction first, the upper tribunal's jurisdiction to hear appeals from the first-tier tribunal is governed by sections 11 and 12 of the Tribunal's Courts and Enforcement Act 2007. Section 11.1, which is in the authorities bundle at page 9, makes it clear that an appeal to the upper tribunal from the first year tribunal is available only on a point of law. There is no appeal on facts. Section 12.1, this is page 14 of the authorities bundle, sets out the task of the upper tribunal in hearing such appeals. The question for the upper tribunal, as subsection 1 makes it plain, is whether the first year tribunal's decision contained an error of law. The power to set aside that decision under subsection 2 only arises where the upper tribunal answers that question in the affirmative. So there is no jurisdiction, there's no power to set aside the first year tribunal's decision absent an error of law. Now, the principles that the upper tribunal must apply in hearing appeals from the first year tribunal are summarized in my replacement skeleton argument at paragraph 29.
In fact, we don't have anything labelled replacement skeleton argument, or at least I don't. But I assume it's replacement only in the sense that the references have been put in. It's not, the text isn't different.
No, and I have deleted parts that are not relevant. Namely,
Oh, I wondered about that. Oh, well,
Something called replacement skeleton.
No, I haven't. I've just got appellant skeleton argument dated.
Well-
Mine's dated the 24th of March.
clearly someone has done the right thing, because otherwise my lord wouldn't have it, but something's gone wrong at our end.
yes.
Do you happen to have spare copies? If not, with a bit of intelligence, we can easily.
I can forward it.
Super efficient.
If it's a problem, I don't want.
It's not a problem.
It'll just mean we can do cross-referencing more easily. Well, I'm sorry, I don't know what's happened there, but
So I wonder if the court has Miller and Friends replacement skeleton argument.
well, that's a nice point. Is that more substantial? The one I've got doesn't say replacement. Is the replacement?
There is a replacement. It does just
It just adds references.
just as references. There may be the occasional typo. Correct.
No, well, in that it doesn't look as though any substantive problems will be caused by any of this.
I have 2 spare copies in any
Well.
event.
Does my lord have this one as well?
I think so.
Yes. May we have the 2 spare copies? You've obviously both had long experience of the court not having the documents they're supposed to have.
Yeah.
Just while we're on this, we were a bit surprised, although we saw why logically, since it's only issue. Well, we haven't got a supplementary bundle. We're not supposed to have, are we?
No,
No.
not in this case. No.
Thank you very much.
Yes, please. Thank you.
Right, thank you.
So it's paragraph 29 of my replacement skeleton argument. So I've identified 6 principles. I've referred the court to the relevant authorities and paragraph numbers. And I do not propose to take the court to those authorities. There is no dispute about those principles, that the upper tribunal should not rush to find an error of law simply because it might have reached a different decision or expressed it differently. Where a point is not expressly mentioned, it should not be assumed that it hasn't been taken into account.
I mean, that's the one you need in particular, isn't it?
Yes. So when it comes to the reasons given by the first year tribunal, the upper tribunal should not assume that the first year tribunal misdirected itself just because not every step in the reasoning
that
is
one
fully
too.
set out.
Yeah.
And the basis on which the first year tribunal decision is made may be set out directly or by inference. A judge is expected to be aware of the relevant authorities and seeking to apply them without needing to refer them expressly. And finally, the nature of the assessment, proportionality assessment, is that different tribunals without illegality or irrationality may reach different conclusions on the same facts. And the fact that one tribunal has reached what may seem an unusually generous view of facts does not mean that it has made an error of law. So these are the principles by reference to which I'll respectfully invite my lords and my lady to assess whether the first year tribunal has made an error of law. It's just moving on to the statutory regime about the foreign criminals. In the authorities bundle, you have Part 5A of the Nationality, Immigration and Asylum Act 2002, starting at page 2. And the relevant section, of course, is the relevant section is section 117C. You have that provision at page 5 of the bundle. The court is aware of the provision, of course. You'll see that subsection 3 refers to 2 exceptions, but there is also a reference to those who have received a sentence for for more than 4 years. So where it's a case about a medium offender who has received a sentence of less than 4 years, the 2 exceptions apply. And where that isn't the case, then it's subsection 6 which applies, and that is the provision that is at the heart of this appeal. Now, can I make three very short points about subsection 6, and I will then take you to 2 authorities to make those points good. The first point that I make is about the phrase over and above in subsection 6. So that is the phrase that comes immediately after the words very compelling circumstances. Now that phrase over and above does not mean in addition to. It is not necessary for a decision maker in the case of a serious offender to make any findings as to the 2 exceptions. A serious offender may rely upon such matters as falling within the 2 exceptions or features falling outside those exceptions.
Don't answer this perhaps until we've gone through all 3 and looked at the authorities, but I take the point that although it would be a very unusual case, in principle you could rely on features falling outside the 2 exceptions for your very compelling circumstances case, where you are in fact relying on the effect of your deportation on your partner or child, in principle the other private life exception as well, you will in practice have to consider exactly the same things as you would have considered under the relevant exception, but applying a higher calibration.
Yes, I mean that was the second and third point that I.
Oh, sorry.
that I was
Those, I
on
should
the
keep
list.
my mouth shut.
Yeah.
Right. Well, let's have your second and third points.
Yes, so the second point is that what a decision maker is required to do as a matter of law in such a case, i.e. a case about a serious offender, is to conduct a full proportionality assessment, weighing the interference with the Article 8 rights against the public interest in the deportation. And in conducting that assessment, the decision maker must proceed on the basis that the public interest requires deportation unless there are very compelling circumstances. And my lord is absolutely right with respect to the full proportionality assessment will necessarily entail the sort of matters that are covered under the two exceptions. And third and final point that I make is about the best interest of the children. So in making an assessment as to whether there are very compelling circumstances, the best interests of the children are a primary consideration. They carry great weight. But natural love between parents and children and desirability of the children being with both parents is not enough. There must be more, there must be something more than natural or normal emotional love. To make the propositions good, may I respectfully take you to two authorities, and in my respectful submission, the court will need to look at only those two authorities in order to decide this appeal. Firstly, this court's judgment in Hache, Iraq, and secondly, the Supreme Court's judgment in Hache, Iraq. This is where this court and the Supreme Court reconciled all earlier authorities on the subject, including the authorities referred to in Miller and Friend's skeleton argument. This court's judgment in Hache, Iraq is at page 40 of the bundle. So this is the case where this court gave authoritative guidance on section 117C of the 2002 Act. If you look at pages 42 and 43 of the bundle, you'll see a catalogue of authorities that were referred to in that case. And those authorities include the authorities that Miller Friend has referred to in her skeleton, including KO Nigeria and NA Pakistan.
Yeah, spelling out the obvious, these were in fact medium offence cases, but both we and the Supreme Court, probably necessarily, but whether necessarily or not, looked also at serious cases.
Absolutely, and I'll add this, that when the matter reached the Supreme Court, a third appeal was joined, the appeal of A, Nigeria. That was an appeal concerning a serious offender.
I'd forgotten that, yes, thank you.
Now, may I respectfully take the court to page 49 of the bundle. So after setting out the relevant statutory provisions, at paragraph 19, my Lord the Vice President referred to NA Pakistan, and you'll see that paragraph and the next two paragraphs refer to two difficulties about construction of section 117C6, the provision that is relevant here. The first point does not arise in this case. It's about a medium offender. And the point was that section 117C6 also applies to a medium offender. The second point is about the phrase over and above. This is paragraph 21. And you'll see that my Lord said that that phrase might be read as excluding circumstances which fell within the scope of the exceptions. And then there is an example. And it was contemplated that a serious offender may not rely on those matters. My Lord said that the court held that that was not what was meant. And there is then a reference to paragraphs 34 and 35 below. Now, if you then go to page 51 of the bundle, you'll see a heading overview. There is with respect to comprehensive discussion as to the statutory regime. Under that heading, what I propose to do is simply to highlight the paragraphs that are directly relevant to this appeal. Now, if you go to paragraph 29, you'll see that my Lord summarized the effect of section 117C in 2 points. Now, those 2 points were expressly endorsed by the Supreme Court when the matter reached there. The first point is about the 2 exceptions. And my lord made the point that when it comes to medium offenders, then a full proportionality assessment is not needed as long as any of the 2 exceptions apply. Those exceptions are a shortcut. The second point, point B, applies here. So my lord said that in cases where the 2 exceptions do not apply, this is that case, a full proportionality assessment is required. So this is what a decision maker is required to do as a matter of law. So when it comes to medium offenders, a decision maker is required to look at the 2 exceptions. When it comes to serious offenders, the decision maker is required to conduct a full proportionality assessment, weighing the interference with Article 8 with the public interest. The decision maker must proceed on the basis that that public interest requires deportation unless there are very compelling circumstances. So no obligation, in my respectful submission, as a matter of law, for the decision maker when dealing with a serious offender to make a definitive finding as to the 2 exceptions. So what is the purpose of subsection 6? The purpose is identified by my lord at paragraph 30. My lord referred to NA Pakistan. And if you look at the last sentence of paragraph 30, this is where the very purpose is identified, and the purpose is to prescribe the weight that has to be given to public interest in deportation when carrying out that assessment in a case where neither exception applies, namely this case. Then look at the next page. You'll see at paragraph 33, my lord deals with the phrase over and above in subsection 6 and quotes from NA Pakistan. So a foreign criminal, just looking at the end of the quotation, is entitled to rely upon matters that he would need to be able to point to features of his case of a kind mentioned in exceptions 1 and 2, or features falling outside the circumstances. So what is clear in my respective submission is over and above does not mean in addition to, as the upper tribunal thought, and I'll seek to demonstrate that when I'll take you to the decisions made below. So serious offender is not required to demonstrate, firstly, that exceptions are met, and secondly, there is something in addition to those exceptions. Just going to paragraph 54, and this.
Roman, just 1
yes.
second, I just want to just look at that back again. You say it follows from the passage you just shown us that it's not necessary to show that the exceptions are met.
Yes.
Ignore for the moment the case where there are features, where he relies on features which don't fall within either exception.
Yes.
And to make it particularly stark, let's assume that no kind of private no exception 1 case is available.
Yes.
The private life is very weak. So we're really looking purely at a family life case. Wouldn't pointing to features of his family life case which makes his claim based on Article 8 especially strong mean that he would have to show not only that exception 2 was met, but that it was met by a considerable, it was met comfortably.
Yes. So
yeah, I just wasn't sure why he doesn't have to show that the exceptions are met. I take your point if there are other features, then that's obviously right. But there aren't in this case, or are there?
The point that I'm seeking to make is that when it comes to a serious offender, there is no requirement in law to make definitive findings as to the two exceptions.
Yes, well, that must be right.
That is the extent of my
Yes, I
submission.
see.
Then moving on, and this is the third point that I made about the children. And this point is of some significance in this particular case. And this is one of the criticisms that the upper tribunal made as to the first year tribunal's reasoning. So if you look at page 54 of the bundle, paragraph 34, you'll see that my lord referred to the earlier case law, and this is the last sentence of the court at paragraph 34. Natural love between parents and children will not be sufficient.
You mean para 34?
Yes, paragraph 34.
Oh, the extract in 34, so sorry, yes.
So the natural love between parents and children will not be sufficient. And my lord then said that, well, it's important to bear that in mind. So there must be some kind of direction or self-direction by the decision maker that natural love, natural bond is not enough. There has to be something more than that. And then paragraph 35 makes a different point about the desirability of the children with both parents, and that too is usually not enough to meet the very compelling circumstances test. You obviously start with the natural love and desirability, and you then see whether there is something more than that outweighs the public interest. My lords and lady will recall that when I showed the court the earlier paragraph in the judgment, which concerns subsection 6, my lord expressly referred to these two provisions, namely paragraph 21. So my lord was considering at paragraph 21 the very compelling circumstances test, and then said at that paragraph, I'll say more about that, paragraphs 34 and 35. And this is what my lord said at paragraph 34 and 35.
Well, funnily enough, I think that's a correct cross-reference. I mean, it's my own judgment. It looks as though I really ought to be referring more to para 33, doesn't it? Doesn't matter, I mean, because what I was saying at para 21 was effectively about what over and above means.
Yes.
And that's actually more what I address at para 33. It's all there, so it doesn't matter what I was referring to.
Yes.
Yeah.
That's that. If you then go to page 62 of the bundle, you'll see a heading just above paragraph 59, the relationship between KO Nigeria and NA Pakistan, the two authorities that Miller and Trent cite in our skeleton argument. You'll see that Malord made the point at paragraph 59 that there was no discussion in KO Nigeria as to subsection 6 and no reference to NA Pakistan. And then paragraph 60, that even where the decision maker is deciding a case about medium offender, where the two exceptions surely apply, there is no requirement in law, even in that case, for the decision maker to make definitive findings about the two exceptions. And what the decision maker can legitimately do is to just move directly to proportionality assessment. If that
Well-
assessment provide a clear answer.
I have to read it a bit carefully. Between D and E, I say in such a case, although the tribunal will inevitably have considered whether the relevant exception has been satisfied, that's the point I was making to you earlier.
Yes.
All I was saying is you don't actually have to tick the box that it has been passed, because there may be other factors which make the overall proportionality assessment clearly in the appellant's favour. I wasn't saying you haven't got to consider those issues. I was merely saying you don't have to make a definitive finding.
Yes.
I only say that's occasionally the case. So,
Yes, but this really is the very last part of that paragraph.
Yeah.
It is not compulsory to take the shortcut if proceeding directly to the proportionality assessment required by Article 8 produces a clear answer in the appellant's favour.
right.
Again, the extent of my submission is that it's plainly the case that when conducting the proportionality assessment, the decision maker will consider the sort of matters that fall within the two exceptions. And that really is the extent of my submission, that it's not compulsory, it's not necessary for the decision maker as a matter of law to make definitive findings. And this, in my submission, applies with greater force to serious offenders, because the two exceptions do not apply in the case of a serious offender. So this is this court's judgment in Hache, Iraq. The paragraphs that are directly relevant to this case. Now take my lords and my lady to the Supreme Court's judgment in this case. This is at page 91 of the bundle. And if you look at paragraph 5 of the judgment, this is page 95. You'll see that that paragraph deals directly with very compelling circumstances. So this is what a decision maker is required to do as a matter of law in the case of a serious offender. The same point that my lord made below, that provision requires a full proportionality assessment. Now, when it comes to the medium offenders, then a full proportionality assessment is not needed, as long as there is a shortcut to that, either of the two exceptions are met. But in other cases, where the two exceptions are not met, in the case of a medium offender, or where the two exceptions do not apply because it's a case of a serious offender, what really matters is a full proportionality assessment. If you then go to page 104 of the bundle, you will see a heading just above paragraph 46, the very compelling circumstances test. And under that heading, there is a discussion as to that provision. If you look at paragraph 47, you'll see that the 2 points that my lord, the Vice President, made were expressly endorsed. Point B is the point that applies here. I've taken you to that point in paragraph 29. In that judgment, makes the point again that what really matters is a full proportionality assessment. Now, what a full proportionality assessment actually entails, and this is the question that my lord, the Vice President, asked me when I opened my submissions. It surely includes the sort of matters that fall within the two exceptions. But if you look at page 106, you'll see a convenient list of matters that are also relevant. all this is very well known. So one has to look at nature and seriousness of the offence, the length of time the person has been in the UK, rehabilitation, the circumstances of the children, their welfare. And it's for the decision maker to weigh up all those competing matters. So again, a failure to meet one of the two exceptions does not necessarily mean that the claim fails. The decision maker must take all that into account. You'll see a heading rehabilitation just above.
Just before you get to that, though, I think one has to note paragraph 52. Because really what's happened is Strasbourg, the law as applied in Strasbourg, of course we're not formally bound by it, we have to pay regard to it, and practical purposes in this area it's been treated as definitive, and that's been so for a long time. Is as helpfully summarised in Unuane, which is what you've taken us to in paragraph 51. There's lots of earlier cases. But Lord Reid in Ali made the point that national authorities can have a say, the weight to be given to those factors, and that's what's happened in the domestic legislation. So there's an overlay
Yes.
on the Strasbourg principles. So it's not enough just to look at Unuane, you've also got to look at the structure required by the domestic legislation in applying the Strasbourg principles. You'd accept that?
Absolutely.
Yeah.
Yes. You'll then see a heading rehabilitation. Now, I've shown section 117C to the court. Rehabilitation is not mentioned in that section. So that section does not say that the public interest in deportation is reduced if there is appropriate, adequate rehabilitation. And that really was one of the issues before the Supreme Court. The Secretary of State was saying that, well, look at the statute, does not say anything about rehabilitation, and therefore it is a matter that is either irrelevant or deserves no or very little weight. Not a very different point is made by the upper tribunal in this case, and that's the reason I propose to show you a couple of paragraphs under that heading. So you'll see that ultimately it became a common ground that rehabilitation was a relevant factor, despite the fact that the statute is silent about it. So that is, so what a person has done is after the offending is relevant. If you then go to page 111 of the bundle, you'll see a heading, the individual appeals, and you'll see that the Supreme Court identified 3 principles. I've identified 6 in my skeleton, but the point essentially is the same. You'll see references to the authorities like AH Sudan and MA Somalia and Jones. It's the same point about the proper approach on appeals. Just one final paragraph, and I'll then address you as to the findings made below. And that paragraph is at page 122 of the bundle. So the Secretary of State argued that the tribunal in that case, the first year tribunal, erred in attaching weight to rehabilitation, to the fact that there was no offending and steps were taken to rehabilitate. That submission was rejected, and it was rejected because the weight to be given to it, the Supreme Court said, was a matter for the fact-finding tribunal. So as long as something is relevant, the weight to be given to it is for the fact-finding tribunal. The appeal court cannot interfere with questions of weight as long as what the fact-finding tribunal has done is either irrational or perverse.
It's fair to say that in the section where he was dealing with rehabilitation, which you just took us to the beginning of,
Yes.
the gist, we can look at it in more detail if you don't think this is a fair summary. The gist is that rehabilitation will rarely be a decisive factor.
Absolutely.
Yeah.
I entirely accept that. I showed you these two passages not to make a point about rehabilitation,
Right.
but to address a different point, a different but similar point that the upper tribunal made. The upper tribunal, I'll take you to the decisions, made a point about criticize the first year tribunal's reasoning as to the delay in making the decision. And I'll deal with that when I'll take you to the decision.
I understand.
So that is so these are the two authorities that in my respectful submission the court will need to look at in order to decide this appeal. All other authorities are discussed within these two authorities.
Thank you, it's very helpful.
May I now take you to the first year tribunal's decision. It's in the appeal bundle, starts at page 84. Paragraphs 1 to 20 are a helpful summary of the background and the evidence. So may I just highlight the passages that are directly relevant in that summary. If you look at paragraph 15, you'll see that the judge there summarized the written evidence. And you'll see that in that paragraph, the judge essentially makes 3 points about the evidence. The first point is about the child D, that the evidence, that there was evidence that he has speech and language and behavioral difficulties. This is the third line. The second point the judge made.
Sorry, just for my education, EHCP, a lady probably knows. No. What does it stand for?
Afraid I don't know the answer. I'm afraid.
Someone can find out.
I'll find out.
DLA, we do understand, that's disability living allowance
Yeah.
for a child, which is a component in universal credit. Is that right?
Yes, so I'll find out the answer. Below.
Thank you.
So that is the first point about the evidence that the judge made. The second point immediately thereafter is about the father's relationship, the appellant's relationship with that child. So there is a very strong bond, in particular about that child. And the third point is about rehabilitation and low risk of reoffending. If you go to the next page.
Hang on 1 second.
Yes, good.
Yes. A difficulty, but it may well be that this is as much a difficulty for the Secretary of State as for you, is that we don't really know what the evidence is. The particular example about going to Euro Disney in itself doesn't seem to me to be particularly powerful, but there may well have been more. This merely purports to be a summary.
Yes.
We just don't know what we told there's evidence indicating a very strong bond. We don't know what it is.
The reason
That's because there isn't a perversity appeal.
yes, there's no challenge on that basis.
So you say we have to proceed on the basis that there is a very strong bond.
Absolutely, these are findings.
We
of
don't
fact.
quite know. Yeah.
Why?
Okay. Yep. Fine.
So I'm very grateful to my learned friends. So EHCP means education and healthcare claim.
It's the equivalent to an old statement
Yes.
of educational needs.
Yes.
Right.
I couldn't remember the acronym.
And what does the P stand for?
Plan.
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 So previously an SEN. Yeah.
Yes. Now, if you then go to again, I'm just focusing on the paragraphs.
Remind me, D at the age of the evidence of the hearing for the tribunal was 7, I think.
Yes. So yes, the child was born on the 13th of February 2013.
The hearing's in March
and this
2021. So in fact, no, not 8.
Yes.
Just 8.
Again, I'm just going to focus on the reasoning about the child.
Yes, of course. No, thank
That's what really matters. But you'll see that there are other parts of the summary that concerns rehabilitation and other things that the appellant has done. So if you then go to paragraphs 19 and 20, and so you'll see the evidence in the form of psychological reports. And you'll see that the appellant is a director of a company, he runs business, supports himself and assists with the children's financial needs. At paragraph 20, the evidence showed that what happened to D when the appellant was sent to prison. D became physically aggressive towards his brother.
That's the appellant's brother, D's uncle. Is that right? D doesn't have a
Yes.
D doesn't have a brother. He has
Yes.
a sister.
Yes, so that must be a reference, yes, to
That's how I read it anyway. And I'm very willing to be, because well, unless I hear to the contrary, I think that must be a reference to
yes.
the uncle, because the uncle had quite a big role while he was in prison.
Yes, so D has a brother.
Oh, does
has
he?
a brother, I'm told, yes. And,
Half brothers or steps, are they?
um,
I'm sorry, I hadn't
There's
picked
4
that up.
children.
Yes. Yes. Okay, well, I was wrong. My lady's picked it up. It's effectively his stepbrother.
yes.
Have I got that right?
No,
Somebody
no,
should know.
there's a single biological mother, and both children are the children of
Oh,
the
perhaps I
appellant.
got it wrong. It's Kay. I thought Kay was a girl.
No.
No, well,
Kay's
sorry.
his
The
brother.
point of a hearing is to sort these things out. So don't be embarrassed to say that I just got it wrong.
So two siblings, brothers.
They're both brothers.
Yes.
Sorry, well that was my misunderstanding. I wonder where it came from. Anyway, it doesn't matter. If that's the position, that's the position. Yeah,
So-
thank you.
So D would have been, when D was physically aggressive towards his sibling,
Yes.
D would have been very young. If it was whilst his father was still in prison.
Yes, but the evidence is that he was aggressive, nothing more than that. It's possible, I would suggest, for a child as young as D to be aggressive.
Anyway, that's the
And
finding
he was a-
without
yes.
more.
No,
We
we
just
don't
have
know,
to take it at face value.
but that's the evidence.
And could I just have the dates that he was in prison? He'd been out of prison by the time of the hearing for almost 3 years, the judge said somewhere. Which at first sounds surprising, but I doubt maybe he was in prison on remand, or maybe he's released before the halfway point. Because if he had 5 years and 8 months, he would have been in for, was it 5 years and 4 months?
Yes. I'll give you the precise
If
dates.
we could have the
and you-
precise-
32 months,
Sorry?
that's 64 months, so we've been in for 32 months.
Yeah.
Or
Yes.
two
So
years,
32.
8 months.
Anyway, if we could have the dates rather than try to work it out.
absolutely. Yes. Yes, so that is a sort of summary of the written evidence about the child. You'll then see a heading, the hearing, just above paragraph 21. So the judge heard evidence about child D, and this is line 5 at paragraph 21. What happened to the children, and D in particular, when the appellant was in prison? Well, naturally, they missed the father, but D displayed particularly challenging behavior. He receives speech and language therapy, and he was not able to hold a pen until he was 6 years old. This is, in my respective submission, quite important. The appellant has taught him in respect of various matters, including communications. He indicated that other children laugh at him because he could not express himself adequately, and D feels like the appellant is his friend.
Could I just ask one other factual question, which I may have got equally wrong? I think both judges refer to the children's mother as the sponsor. They were married according to a Muslim ceremony, but is the position that they're not married as a matter of English law? It's just more natural to refer to her as the wife, but I wondered whether that was the reason.
No. The appellant arrived in the UK in 2011 as spouse of.
Yes, but spouse, I think, you don't have to be formally married. You can be in a relationship akin to marriage, I think.
Yes.
I just want to be accurate and speaking.
It's whether they'd just simply had a nikah,
Yes.
or whether they'd subsequently had a,
Yes.
a civil ceremony
I'll-
as well.
I'll-
And it doesn't matter, but
It-
we would like to be accurate
Absolutely,
and
yes.
respectful to whatever their
Exactly.
relationship
I mean,
is.
to me, the natural way to write this would be to refer to her as the wife.
Yes.
Because although they're separated, they're certainly not, as I understand it, divorced. So if wife is the correct term, I'd rather use that than sponsor, which seems a bit odd in
Yes.
context.
Yes. I'll give you.
Could
the
you?
answer
Could I
to that as
just?
well.
You didn't give me a view on the hoof, but I would just like to know the formal position so we know how to refer to her.
Absolutely.
Thank you.
My lord, if it assists, in the upper tribunal judgment at paragraph 4, they describe the marriage as being pursuant to an Islamic ceremony. That's at page 55.
Yes. No,
Nothing.
that's where I got it from, I think.
Nothing more.
But that wouldn't make it inappropriate to refer to her as the wife.
No, sir.
No.
No.
I'm just puzzled by its sponsor throughout, but it may just be.
Yes.
Okay.
I'll
Thank you.
answer that question as well. So that's so this was the evidence that the judge received at the hearing. Now the judge also heard evidence from the wife. I'll call her. I'll address her as wife. And if you look at page 27, so they are no longer together. But she gave evidence that D had a very close relationship with the appellant. And if the appellant is removed, that D would be devastated. It would have an enormous detrimental emotional effect, who struggled greatly and whose behavior deteriorated significantly while the appellant was in prison. And she did not receive any assistance from family members. So this was the evidence that the judge received at the hearing. If you then go to page 90, you'll see the decision.
Yes, 28, though I see why it's not as important as the other points. If he is deported, she will have, in her current situation, no support from her own family, that she's mentioned that earlier, but also from his family.
Yes,
Because
and
they-
that is an express finding that the first year made subsequently in the decision, but that was the evidence.
Yeah, thank you.
Now you'll then see a heading decision. Now, if you look at paragraph 33 of the decision, you'll see that the judge refers expressly to the immigration rules. Now you have hard copies of those rules. It's common ground that the rules mirror the language and scheme of section 117C of the 2002 Act. Some judges prefer to work from the rules, some prefer to work from the statute. There is no difference between the two. Paragraph 35, the judge expressly acknowledges the seriousness of the offense. The judge acknowledges the sentence.
So just before we get there, it's an oddity. It's really the only place where he directs himself as to the law is in those 4 paragraphs. It's
Yes.
true, of course, that he makes various references to the law as he goes through, but a model reasons, would have started with a rather more elaborate self-direction as to the law and some reference to the governing case law. Now, he makes a passing reference to Razgar, which is good as far as it goes, but he's not really concerned with this situation. Is it a fair criticism that we don't have? I think HA Iraq in the Court of Appeal had been decided by then, hadn't it, or had it not? Even if it hadn't, certainly NA Pakistan.
No.
It is March 2021.
Yes. And Hattie was, it had been, I think,
Yes,
Yes.
it has certainly been decided.
yes.
One would expect, although I know I'm afraid this doesn't always happen, that the representatives of both sides would have ensured the latest case law was before the judge. And anyway, the FTT judges generally are pretty familiar with it. Is it not a bit of a problem that there is no reference to either NA Pakistan or Hesham Ali or most importantly, HA Iraq in the Court of Appeal? That's where he should have been going to as his first source of self-direction, isn't it?
Yes, so it's entirely fair criticism, and anticipating that criticism, I took the court to the 6 principles in my skeleton at the outset. So one can surely criticize the drafting style of this
Yes.
judge. One can criticize him for the fact that the decision is not as structured as it should have been. My lord is absolutely right that a different judge would entirely legitimately would set out the relevant case law, but that surely is not the test.
I take your point, and your answer may be a sufficient answer to it, but it's not just that this is not perfectly constructed. It's that there is no reference to what was then the leading case law.
Yes.
Anyway, I don't want to bat you about it. I just want to identify that, and we don't, I think, have an explanation for that.
No,
Just lost in the way.
That was the point that the Secretary of State made, and I'm afraid I made that point in Nigeria for the Secretary of State. And this court made it clear that, well, judges in this jurisdiction are expected to be aware of the relevant authorities and applying them. So the principle that my lord will apply is whether it is clear from the language that this judge has used that this judge has failed to follow the authorities. And it's not, in my submission, so clear from the language that this judge has used.
Yeah. Okay. Thank you.
So there is an express reference to the rules mirroring the language at paragraph 33. The paragraph 35 is the self-direction. And self-direction is absolutely correct. So
you're talking specifically about the final sentence of 35.
Yes. And then if you look at paragraph 36, the judge makes a finding that the exceptions do not apply to the appellant because he has been sentenced to a term of 5 years plus in the UK. So in my respectful submission, in a way that is less than ideal, the judge is following a structure. He's starting off with the rules. There's a self-direction. There is then a finding that exceptions do not apply. And once the judge has made that finding, what follows in the subsequent paragraphs, in my submission, is the full proportionality assessment that this judge was obliged to do. Again, just focusing on the findings about the child. Paragraph 38.
What's the point of paragraph 37?
Well, I think it's about the exception.
It's about exception 1. Well, the first bit of it, it's not really about exception 1 because these are not the factors in it. These are private life considerations, but they're not as expressed in exception 1, are they?
No, that is right. I think, I mean, the exception is about half of the life in the UK.
Yes.
Um,
So all we can say is he was basically saying, he's making some points about the private life, but they don't.
no, that's
But in a sense, you're right. I mean, if what he effectively did was put the exceptions and the language of the exceptions to one side
yes.
and went straight into a proportionality assessment, you wouldn't expect him in 37 to be looking at exception 1. I think I'm right in saying these are, the 20 years or more comes from para 276 ADE, doesn't it? Or what we used?
That's right. It's now yes in a different part of the immigration rules. It's appendix private life.
Yeah.
But prior to the enactment of Part 5, the rules that were in place even for deportation, I think referred to a period of residence of 20 years or more. I just
Yeah,
need
so
to,
he basically, I think what I'm noting to myself, unless you think this is wrong, he was making a point about private life by reference to the general provisions about private life rather than exception 1. Is that a fair summary?
yes, that is a fair summary, and he did that because it seems this is the first sentence of paragraph 36. He took the view correctly that the exceptions do not actually apply.
Yeah, we can see, the more you look at it, the more you can see how he was thinking of it.
Yes.
He was basically saying, I needn't bother with the exceptions as such.
Yes.
But you would say he did bother with the private and family life questions, which he would have had to consider if he had been applying the exceptions.
Yes, absolutely.
Yeah.
Now, if you then look at paragraph 38, the judge accepts the evidence about D. This is second last sentence of paragraph 38. D has a speech and language and behavioral issues, and I accept that he's particularly close to the appellant, who provides a calming and guiding influence on him. And when I will show you the upper tribunal's decision, I'll seek to demonstrate that the upper tribunal actually criticized the judge for doing this, what he was actually required to do by the case law. If you then look at paragraph 39, so the judge makes a finding that D has, the issues are significant. He gets one-to-one support at school. The judge accepts that the behavior deteriorated while the appellant was in prison, and that evidence was confirmed by the school. And then this is really the point that my lord made in Hatch Iraq by reference to the earlier case law. The judge said that the appellant's relationship with D is particularly strong and extends beyond normal family ties. Now, what the judge in my estimation had in mind was that normal love between a parent and a child is not enough. There must be something more than that. And the judge makes a finding of fact that there is something more in this particular case. So the judge looked at.
So he clicked whether or not he actually had NA Pakistan, which I think is the clearest statement of that principle, in front of him. He was aware of it.
Yes, my lord, I was proposing to take you through the relevant paragraphs.
Yes, I'm sorry.
In sequence, but given that the point is troubling, my lord, may I just ask my lord to look at paragraph 46, where the judge refers to the appropriate case law, in particular A, Nigeria. So this followed Hatch Iraq, where Hatch Iraq was considered NA Pakistan, KO Nigeria. So these authorities were before the judge.
Yes, I was going to ask you about those, but yeah.
Yes.
Can we
Yes.
flag that? But let's wait till we get that. Yeah.
So these are findings about D. So paragraph 40, the judge acknowledges again that the offending is quite serious. And then makes, in my submission, two particular points. The first point is about rehabilitation. He's been out of prison for some time. There's no conviction. Has established a business. He creates employments. The second point, which is linked to the first point, is that the sponsor is estranged from her own family members. The brother has moved outside. This is what my lord asked, and the evidence is that there's no one else to assist mother with upbringing of the child. We then have paragraph 41. The judge acknowledged the public interest in the appellant's deportation, and it is the second and third sentence of paragraph 41 that were picked by the upper tribunal. And in my submission, the upper tribunal misread those paragraphs. The judge acknowledged the public interest and then said that, well, there's also a public interest in keeping the appellant in the UK in order to provide extremely valuable support, both financially and emotionally, in raising the children. Now, it is debatable as to whether that is a private interest or a public interest. But what the judge was doing there was surely weighing up the public interest in deportation against the interests of the children. And the fact that the appellant was providing financial and emotional support to children. I do ask my lords and my lady to take a particular note of the second sentence, and I'll ask the court in due course to compare it with what the upper tribunal actually said. You then have a sentence that
Hang
if
on
the...
1 second.
Yes.
So you're saying it would be completely unexceptionable if he had said, however, there is also an interest in keeping the appellant in the UK in order to provide extremely valuable support in raising his children, especially D, because then he's simply weighing, as you say, the interest, the public interest in deportation against the interest of the children. The problem, which you say it doesn't really matter, is that he called it a public interest.
Yes.
Yeah.
That is the submission, and I do ask my lord to look at that particular sentence. If one can criticize that sentence, the criticism can only be directed to the word public, nothing else. But the upper tribunal, in my submission, simply misread what was being said. And then, so the point was about that the appellant is providing financial and emotional support to children. That was the point that was being made. And then that the appellant has a strong relationship with the family members.
Well, you've skipped over the sentence, the third sentence there, about the considerable additional drain on the public purse, which has to be read with the second sentence, doesn't it?
Well, so the point in the second sentence, in my respectful submission, is about the financial and emotional support that the father provides to the children. And it is, the judge is weighing that against the public interest. The third sentence in my respectful submission is an additional comment that if the appellant is deported from the UK, there would be considerable additional drain on public purse. That cannot, in my submission, exclusively be related to the public interest referred in the second sentence, because the second sentence refers not only to financial but also emotional support to the children. So in my submission, this is a further additional point that the judge was seeking to make.
Is it a legitimate additional point?
Well, my submission is twofold. First, it is a legitimate point when it comes to full proportionality assessment. In my respectful submission, it cannot be said that matter, the impact on public purse is irrelevant. Now, if the court concludes that the matter is relevant, then the weight to be given to that matter is for the fact-finding tribunal. So it's not a matter that is irrelevant. That is the first submission. Secondly, in any event, this particular sentence played no material part in the ultimate process. The judge is not saying that the public interest is reduced because of the impact on public purse, or that is the reason why the appeal succeeds. It's quite clear in my submission, if one reads the decision as a whole, that the appeal succeeds because of the potential impact on D of the appellant's deportation.
Might say it was a little rhetorical flourish rather than the essence of the argument.
Yes. Yes. So that's that. Then paragraph 42. So this is where the judge refers to the delay in making a decision on this case. In my submission, the upper tribunal misread that paragraph too.
So sorry. On 41.
Yeah, so you've looked at 41, so it's 42 now, my lord.
Yes, I don't. The reference to Gissing and Bioku Betts,
Yes.
I think I've taken from your Stellis nor Pasmus Manion's. I haven't, I'm afraid, looked at those cases. I have in the past. But all the judge is saying is the trite point that the family life interests are not only, indeed not normally primarily, those of the parent who's about to be deported,
Yes.
but are those of the child or spouse who's going to be affected by the departure.
Yes.
That we don't need to look at those cases. That's what he's saying.
This is what the judge was saying, and this in my submission reinforces the submission that I was seeking to make. That this paragraph is not about the impact on public purse at all. It's about the support that the father provides to the children and the impact on D. So paragraph 42. The human rights claim was made on 26th of June 2018. The Secretary of State did not decide it until 14th of January 2021. And the judge said that this was indicative of the fact that the removal was not a priority. To be indicative are the words that I would respectfully invite my lords to highlight. So the judge is not making a sort of definitive finding that the removal was not priority, merely saying that that was indicative. But the real point that judge was making is that, well, a human rights claim was made in 2018. It wasn't decided until 2021. So I now have to look at what has happened in the meantime. This is what the judge was saying, that, well, the Secretary of State did not make a decision promptly, and in the meantime, the appellant has cemented his family and private life in this country. So this isn't simply an isolated point that, well, there was a delay, and that delay means that the public interest is diminished. The judge is saying that, well, because of that delay, I now have the evidence that there is low risk of reoffending, and the fact that a family and private life has been further established. So not a freestanding delay point, but a point that is linked with what has happened. 43, the judge again repeats that there's a strong family life with the children, acknowledge the particularly compelling circumstances arising out of the relationship with D.
This may not matter. He didn't say particularly compelling, which might be a paraphrase for very compelling. He said particular compelling circumstances. I'm sorry if I'm being picky, but it's a pity he doesn't use the phrase, pity from your point of view, he doesn't use the phrase very compelling.
Yeah.
But anyway, there we are.
No, but the ultimate finding is that the appellant's removal would be disproportionate in all the circumstances. So very compelling circumstances. Test is one that judge expressly identified.
He did.
He was required to conduct full proportionality assessment. This is what the judge did. Then just moving on to the next page, page 92, paragraph 45, the judge said that, well, the appellant has been in this country for 18 years. He came here when he was 15, but that alone, the judge said, was not enough to make the deportation disproportionate.
He says on the basis of his private life alone. I mean, my reading of this is that although clearly the most important factor was the impact on the children and more specifically on D, he did take into account
Yes,
that this was okay, someone who'd been here a very long time, since the age of 15, and the other private life factors,
yes,
that while obviously realistically acknowledging they weren't enough on their own.
absolutely. And not only that, his character otherwise, apart from the offending, rehabilitation, his business interests, the fact that he has created employment in the UK, the judge said that, well, I wouldn't have allowed the appeal on that basis, but I got to look at that in the circumstances. You then have paragraph 46. My lord had a question about that paragraph, and I suspect that it's about the authorities that the judge has referred to
Yes.
without any citation.
I didn't have the opportunity, I'm afraid, to look them all up. Some of them I'm broadly familiar with. I think Binloss must be
Binloss, yes.
slightly misspelled. It wasn't entirely clear to me from my limited knowledge why they were relevant. They're presumably all cases that were cited to him, or maybe not. Maybe they were from his own researches. I mean, he spent a long time over this judgment, I noticed. Quite a long, 5 months, I think. But what can you just tell us what the relevance of those authorities is on your submission?
I think the judge simply wanted the reader to know that, well, he's aware of those authorities and took them into account.
Yes, but what do they say that's particularly relevant?
But, just picking AA Nigeria in particular, I mean, it summarizes the effect of HA Iraq, deals
Yes,
with
I
AA
see. This is
Nigeria.
AA Nigeria in the Court of Appeal.
Yes,
Yes.
I referred to that in my skeleton.
Sorry, I'm sure you did, and I obviously haven't picked it
Yeah,
up. We haven't actually got it, but it's easy enough to find.
No, but AA Nigeria is simply, in my submission, is simply a summary of summary of the earlier case law. HA Iraq.
Maybe, I mean, I don't know, I don't think it'd be inappropriate for us to have instructions on this if you have them, but I think it was conducted by your instructing solicitor, wasn't it, in this
Yes.
case? In the FTT, whether this was an authority that was actually put before him.
Yes.
But if we looked at it, I think I remember it. It was a decision of Lord Justice Popplewell, wasn't it?
That's absolutely right. Yes.
And as you say, he referred to HA Iraq.
Yes.
Eventually, it went up to the Supreme Court with HA Iraq.
Yes.
So it may well have been the most authoritative recent statement of the
Yes.
law.
Yes. But I cannot say for sure that, well, this is the AA Nigeria the judge had in mind. I'll take instructions and I'll give you the answer shortly as to whether
That was
the AA Nigeria.
that would be helpful. And obviously Ms. Mannion wasn't there either.
Yeah.
I don't know whether
But
the vetting officer who was is in court. But
so, Lord, I'm not. I'll answer the question, Lord, but I'm not asking you to uphold the decision simply because there is a reference to the case law at paragraph 46. That the point is that the question for my lords and lady is that, is it clear from the language used by the judge that he did not apply the relevant authorities?
I do get that point, and it's entirely realistic of you, but we want to do justice to the judge.
Yes.
So far as appropriate. We want to see what was in his mind. And here we got 4 cases, which in his concluding paragraph he says he's had regard to. And I just think we ought, if possible, to know, it may not be possible, but we ought to see why he thought they were relevant.
Yes.
And AA Nigeria, if it's the right one, that will be fine.
Yes.
Binloss I am a bit puzzled by, but because that's the one that went to the Chiari and Binloss went to the Supreme Court, but really on a completely different point, didn't it?
Yes, but it makes the point that it's ultimately for the fact-finding tribunal to assess proportionality rather than simply reviewing the Secretary of State's
That wouldn't be a very relevant thing. Oh, I see. All right.
decision.
But these may be cases which, and I mean, no disrespect to your solicitor, perhaps not all entirely relevant, the ones that he was referred to, and he was just saying, I've had, or indeed maybe the Home Office referred to them,
Yes.
and he was the one saying, I bear them all in mind. So it'd be quite nice to know why they were in front of him.
Yes.
If we can't find out, so be it.
Yes. I'll answer that question as well. So that is what.
Right, sorry, you were now into the rest of the paragraph.
Yeah, so this is where the ultimate conclusion. The judge again acknowledges, this is the third sentence, there is a strong public interest in the appellant's deportation. It weighs that public interest.
And he doesn't actually express it quite accurately, does he? It's a strong public interest in maintaining law and order and public protection. In fact, the public interest in deportation has other elements in it as well, doesn't it? It has deterrence and marking public disapproval.
Yeah.
Yeah.
Yes, but then
But still, it does say strong public interest.
yes, and yes, and then the judge focuses in my submission on the children, refers to other matters as well,
Yeah.
but noted in particular these significant issues, and concludes that deportation is neither justified nor proportionate.
Yeah.
One may criticize this decision about the structure or language. But in my submission, this is a decision that was open to the judge, should be respected. One may think that it is a decision that is generous to the appellant, but different judges may come to different decisions on the same facts.
And on that point, you're entitled to bear in mind the fact that they well strike us as generous, but we didn't see the evidence.
Yeah.
It would be perfectly possible to have a
Yes.
perversity challenge, in which case we'd have seen all the evidence and said, well, this is incredibly thin, but we're not in a position to say that.
Yeah. And this is yes, absolutely. And Lady Hale's point in Lebanon referred to that in my letter,
Yeah.
that without irrationality or perversity, a generous decision cannot be interfered with, and there is no respondent's notice, no challenge on perversity or rationality grounds.
Okay.
So then, in my submission, this court will then look at the upper tribunal's decision to see why the upper tribunal felt it appropriate to interfere with that decision. So the upper tribunal's decision starts at paragraph 54 of the bundle. And may I just take the court straight to the heart of the decision, where there is discussion. And the discussion starts at page 59, under the heading discussion, just above paragraph 31.
Sorry, what paragraph?
Paragraph 31, just above that paragraph, there's a heading discussion.
Should we just note that he did the three grounds of appeal are identified at para 19,
Yes.
and I'm not sure this point helps anyone on either side, but I just flag up in case anyone wants to say anything about it, that his reasons don't exactly correspond to those grounds.
Yes. Yes, and perhaps the reason for that is at paragraph 31, because at that paragraph,
Yeah.
the judge agreed with the appellant that the Secretary of State's case, at least in part, is a mere disagreement, and much of the submissions that were made by the Secretary of State were disagreements and did not demonstrate that those findings were not open to the judge. So what this judge is saying is that, well, everything is mere disagreement apart from the 2 points. See paragraph 32. I find that the remaining grounds of appeal demonstrate that the judge fell into error. So the remaining grounds are the grounds of the points that the judge then discussed.
Okay.
So the first point is at paragraph 31. The judge did not expressly conduct the analysis pursuant to the structure and statutory considerations. Two points that I make. The first is that in a less than ideal way, the judge did conduct the assessment by reference to the structure and considerations in Part 5A. The judge identified the sentence, identified the exceptions, held that they were not meant, then looked at the proportionality assessment. The judge then says that, well, the judge below identified some of the correct concepts. This, with respect, is an unfair criticism. In my submission, all the concepts that the judge below identified were correct. It's not sufficient for the upper tribunal to say that, well, only some of those were correct.
Well, just to anticipate, I think it's fairly clear he had in mind that there was no reference to the concept of undue harshness. But
Yes.
you're going to say that isn't an essential concept.
No, that is a submission. And see what the judge actually said at paragraph 35. So the judge refers to section 1176 and then says this is fourth line: what amounts to very compelling circumstances in an assessment that must be informed by the extent to which the claimed very circumstances exceed the factors set out in exceptions, exceed and must, the words to emphasize on. Over and above, that phrase does not mean in addition to or in excess of. Must is no, it's not necessary for the judge to look at the two exceptions. And the point is reinforced by what the judge said at paragraph 36. Since any assessment of very compelling circumstances must be conducted by reference to the extent to which the appellant meets the substance of the exceptions. That, with respect, is wrong in law. It was incumbent upon the judge to expressly consider those exceptions. Any, must, incumbent, expressly, they all demonstrate that the judge got the law wrong. There was no obligation on the judge below to expressly look at the two exceptions. It wasn't incumbent on that judge to make definitive findings about that exception. Then look at paragraph 37, the judge refers to...
Just interesting to look at the extract from N.A. Pakistan,
Yes.
which he quotes in support of his propositions. In relation to a serious offender, often be sensible first to see whether his case involves circumstances of this kind,
Yes.
both because the circumstances set out particularly significant factors bearing on such a private life and family life, and because that may provide a helpful basis on which an assessment should be made as to it. That's very much the language of sensible and helpful, not of legal requirement.
Yes, but see what the judge says at 37 immediately after that. It
Right.
follows that it was incumbent upon the judge to address the substance of the two. It does not follow in my submission from that passage that it was incumbent on the first tier tribunal judge to address the two exceptions. But he did address the two exceptions, said that exceptions do not apply expressly in the decision.
Do we take the same lenient approach to this kind of language in the upper tribunal's reasoning as we do to the first tier tribunals? As we do.
In my submission, the answer is no, because what the court is deciding essentially ultimately is whether the first judge made an error on a point of law for the reasons given by the upper tribunal. But what is, so I'm not just picking one word at paragraph 37. I took my lords and lady to paragraph 33 and 35 and 36. The judge plainly felt that there was a requirement in law for a fact-finding judge to make definitive findings about the two exceptions. This is surely not what was said. But then you'll see a reference to H.A. Iraq just immediately after the quote at paragraph 37. The judge paused to observe that since the hearing, the Supreme Court has handed down H.A. Iraq, but then felt that, well, that simply addressed the term unduly harsh. And for the present purposes, nothing turns on this because the Supreme Court endorsed that test. But the Supreme Court said quite a lot about proper approach on appeals from the first tier tribunal to the upper tribunal on the very compelling circumstances test. that what it really requires is a full proportionality assessment. If there is any doubt about the submissions that I've made thus far, the doubt in my submission will end if one looks at the first sentence of paragraph 38. The judge below is criticized for not in terms addressing the two exceptions. In terms, the judge did not in terms address the two exceptions in the operative reasoning. There's no obligation on the judge to do that. So the first,
I don't think you took us actually to those paragraphs in the FTT decision. Let me just remind myself.
It's 33 to 36.
Is that right? Surely. Paras 8 and 10 of the decision. Surely that's paras 86. Are we across purposes? Page 86.
Yes.
Yes, I see 8. Yes, I see. So this is really what he's doing. He is just simply summarising the Secretary of State's decision, which no doubt we haven't seen, or if we have seen, I haven't read, which no doubt very.
Is the Secretary of State's factual case on the unduly harsh test that is being referred to in paragraph 30?
All it demonstrates is that the words unduly harsh were, the judge certainly had typed them, was aware of them,
Yes.
because they've been used in passages that he referred to. But that.
And he then expressly refers to the exceptions and say that the exceptions
Well,
do
we
not
know.
apply.
I think we can see quite clearly why he didn't think he needed to, because he
Yes.
thought this isn't an exceptions case.
No.
Yeah, and you say he was right.
Yes,
Yeah.
in my submission, yeah. So paragraph 38 is
Sorry. Yes.
38 of the upper tribunal's decision, page
Yeah.
60. So the upper tier tribunal was wrong to say that there is an error of law because it wasn't in terms addressing of the exceptions. So that's the first reason given by the upper tribunal for interfering with the decision. The second, or the sort of linked reason, is at paragraph 39. So this is where, in my submission, the upper tribunal judge is criticizing the first judge for doing what my lord, the vice president, said in HA Iraq must be done. So this is where the judge said that, well, the first judge made a passing remark that the relationship between the claimant, between the appellant and D extends beyond normal emotional ties.
Normal familial ties.
Not normal familial ties. Yes, but what the 2 points that I make. The first, it wasn't merely a passing remark. It was a finding of fact, surely based on the evidence. Secondly, this is precisely what my lord the vice president said by reference to the earlier case law, that normal love is not enough. There must be something more than that. So that criticism in my submission is unjustified. The first judge appreciated that the normal love and bond is not enough, then considered whether there is something more than that, and then to criticize that approach as being language of adult dependency in my submission.
I'm not sure what's meant by that. Given
Yes.
that the authorities require something more than normal
Yes.
familial ties.
Yes, so there is
In the context of a relationship with a child, why, when they use that phrase, is that deemed to be
Yes.
in relation to?
Yeah, so there is some case law on the subject as to the relationship between adult siblings or between an adult child and parents, and the courts have said that the question as to whether Article 8 is actually engaged, not the question of proportionality, whether Article 8 is engaged.
Oh, those rather old cases. Yes.
Kogatas.
Yes.
Yeah.
There's a decision of Mr. Justice Sedley, I think, or Lord Justice Sedley, whichever he then
Yes, yes.
that's right, saying siblings don't normally come with it. Sibling relationships aren't called biological age normally.
Yes.
So he's basically, I dare say he's right about that. That the phrase is in the case law in that context. But you presumably would say that the fact that the judge used that particular phrase is neither here nor there. It's quite clear what he meant in the context.
Yes, but even in that case law, that phrase does not appear. So the test under Kogathas in that line of case law is whether
For Ugathas, that's the case. Yeah.
Kogathas, whether there is something more than normal emotional ties. That was the
Sorry.
reason I slipped when I was making my submission. So when it comes to adult siblings, the test of engagement of Article 8 is whether there is something more than normal emotional ties. There's no basis in my submission for the upper tribunal to say that, well, that is what the judge was doing. Surely the first judge wasn't doing that. Surely the judge had in mind the case law concerning deportation, that normal love is not enough. The judge was looking whether there is something more than that. So that criticism is also unjustified, and it was wrong for the upper tribunal to categorize that as a passing remark. It wasn't a passing remark.
But then, yes, but he then goes on to say, well, he just sort of acknowledged that he might have meant that ties in claimant and deed were stronger than those ordinary families in father and son.
Yes.
But what do you have to say about what he says about that?
Well, yes, but then
Sorry.
yes. So if so, just read that in my submission with the next sentence. So the
Yeah,
judge is
sorry.
saying that, well, what the judge should have done was should have applied the unduly harsh test rather than just focusing on the bond between the two. That with respect is simply wrong. It's not justified on HA Iraq. When it comes to the assessment under section 117C6, this court made it absolutely clear. You look at the relationship, you decide whether what is there is more than normal emotional love, conduct a full proportionality assessment, and then decide whether deportation is justified or not. The judge was not required in my submission to apply the unduly harsh test in this particular case. This is a case about serious offender, not about a mere medium offender.
And in a sense, it's a false dichotomy, isn't it? Even if he was, in one sense, required or would be desirable, at any rate, for him to use the language of unduly harsh,
Yes.
in deciding whether this is unduly harsh, the first question I asked is this more than
that, yes.
than an ordinary parent relationship?
Absolutely.
So there's not really a contrast.
Yeah. But in yes, absolutely. And in the final sentence, I'm sure the court will speak the words the test. That this surely is not the test that the judge below was obliged to apply. When I showed Lord the first judge's decision, I asked my Lord to take a particular note of what the first judge said about said at paragraph 41. If you then compare it with paragraph 40, this is the third point that is made by the judge, that the upper tier judge says that he impermissibly held that there was a public interest in keeping the claimant in the UK, these are the inverted commas, due to the impact of public funds. This surely is not what the judge said. The judge said something completely different. The judge said that the public interest, that the interest in keeping the appellant in the UK is based on the financial and emotional support that the appellant provides. So what this judge did in my submission was this judge quoted 4 words, a public interest in keeping the claimant in the UK, then simply omitted the rest of the sentence that the first judge used at paragraph 41 and went straight to the second last sentence in that paragraph.
I'm a bit puzzled about this. I thought that the finding was that the father could provide financial support wherever he was.
Yes, but at paragraph 41, the judge makes 2 points. First, about the financial support, and secondly, the emotional support.
Yeah. So the financial support isn't a reason for keeping him in the UK because he could provide that wherever he was.
yes, I mean, yes,
Yes, that's
The
not the
judge
point the
would-
judge is making here.
yes, so that, yes, I mean, I would have been impossible for me to defend the first judge's decision if it was premised on financial support. But the submission that I'm making about paragraph 40 of the upper tribunal's decision is that it is based on a misreading of paragraph 41.
Yep.
So you look at paragraph 41 of the first judge's decision, you compare it with paragraph 40 of the upper tier tribunal's decision, you'll see that what the upper tribunal judge was impermissibly picked a couple of few words, skipped over the rest of the paragraph, then picked a point about the public funds, and then took the view that is what the judge was doing. So that is the first point that I make. The
Sorry,
second
just
point,
before you go there, I just want to remind myself where there is a finding. I appreciate what you say, this isn't the core of the point anyway. Where is there a finding that he could have provided financial support from Turkey if moved?
I'm not.
It rings a bell with me, but I'm not quite sure from where.
You know, I'm not with respect entirely sure that there is actually a finding to that effect. My Lord put a question to me, and I said
Yeah, no, I understand, but just as it came up, I just wanted to.
I don't think that there is a
I
finding.
don't think there is such a finding. It may have come up in the submissions. I mean, it wouldn't be an unreasonable finding, but it all depends.
No, but
Yeah.
that
Thank you. Okay.
isn't a finding. Yes, so I've taken you to the actual findings to almost every paragraph.
Yeah, no, I couldn't.
There isn't a finding. So you have my first point about paragraph 40 that the judge simply misreads paragraph 41. But there is a second point, and there is a further error of law in paragraph 40 of the upper tribunal's decision. If you look at the concluding sentence of that paragraph, the judge says that, well, the potential burden on public funds is not a factor which Parliament has ascribed any significance. So look at section 117C. Potential burden on public funds is not a factor that Parliament has ascribed significance, and the judge was wrong to look at it. But well, sure, this is the same submission that the Home Secretary was making in respect of rehabilitation before the Supreme Court. That look at section 117C, Parliament has not ascribed any weight to lack of further offending. That means that it's irrelevant. But surely when it comes to a full proportionality assessment, everything is relevant, or it's difficult to say that it's not. So the fact that Parliament has not ascribed any significance in the primary legislation to that factor does not make that factor irrelevant. In the proportionality assessment, the matter is relevant. The weight to be given to it is a matter for the fact-finding judge. And the judge below was not seeking to redefine the public interest, was merely conducting a conventional proportionality assessment. So finally, paragraph 41 of the upper tribunal's decision, page 61, the judge said that it is necessary to address the judge's remarks about the claimant's removal from the UK, not a priority. And the upper tribunal judge says that was inappropriate. Well, three very short points. The first is that when I showed you the relevant paragraphs, there is no finding that the claimant's removal was not a priority. The judge merely said that it indicates what has happened is indicative of the fact that removal was not a priority. Secondly, what the judge was actually doing below at paragraph 42 was saying that, well, the human rights decision was made in 2018, the human rights claim was made in 2018, it was refused in 2021. What has happened in the meantime? To use the words used by the judge below, during that time, the appellant has cemented his family and private life in the country. So it wasn't, as I submitted earlier, a freestanding submission that the delay means that the public interest is gone. And finally, the judge says that I consider this criticism to be inappropriate. Well, so be it if I'm wrong about my first 2 points. The fact that the upper tribunal considers a point made by the first judge to be inappropriate does not mean that the point is wrong in law. The jurisdiction only arises to set aside the decision if there is perversity or irrationality. The judge in the upper tribunal is not saying that the finding or the comment is irrational or was not open to the judge below. Inappropriate is a classic disagreement. It's not an error of law.
It's actually a bit of a puzzle how 41 fits in, because he says 2 points, which he identifies as first, starting at 35, and second, starting at para 40. 41 is a different point, it's got nothing to do with the other two. It's not called third. It starts, as I conclude, it is necessary to address. Don't quite know. I did wonder whether it was a slip. It is unnecessary. Why feel? But actually, it's just a bit of a puzzle. I don't quite see how that fits in. But if it is meant to be a further ground on which he overturned the decision of the FTT, we had those submissions on it.
I think it's more in the form of a postscript.
Yeah. Yes.
As I conclude, as I come to the end,
Yes.
it's necessary to address the judge's remark.
Yes. I mean, the reason why I thought I'll make this submission is because of what the judge said at 42, that these errors
Yeah.
and
Yeah.
all these
No, I
errors.
agree, I agree.
included at 41.
Perhaps we can say, without disrespect, this isn't a perfect decision either.
So for these reasons, I respectfully submit that the upper tribunal was just not happy with the first judge's decision.
Yeah.
Disagreed with it, and for that reason decided to set aside it. There is no error of law. I ask you respectfully to restore the first judge's decision. So unless I can assist you any further, these are my submissions.
Yeah, that's very
I'll
helpful.
provide answer to
Well,
these 3 questions.
Thank you.
Just one moment. Are you happy for me to say to this man she doesn't have to finish in half an hour? You're no problem. It's fine. You haven't got commitments in the afternoon. Sorry, yes, you're going to answer the questions.
So I'll answer those questions in due course.
Okay, that's fine. Ms. Mannion, I see this had a half-day listing, and at first I thought that was totally realistic. We have, however, kept Mr. Malik on his feet for quite a long time.
It's been extremely
Don't feel
helpful.
obliged. You, I'm sure, can be a lot shorter because you haven't got to do the groundwork, but you certainly don't feel you need finish in half an hour.
I'm grateful, and no doubt the lunchtime adjournment will make me yet quicker in any event on final submissions, as is often the case.
Yeah, and could you just bear in mind, you have the disadvantage of being very proper and sitting one row back, but I at least am getting older, so you need to pitch your voice up a bit.
Thank you for the warning. If at any stage I drop too quietly, please, my lord, indicate. The Secretary of State's position, my lords, my lady, is that the upper tribunal was correct to find 2 material errors of law in the first-tier tribunal decision in this case. Read fairly and completely, the approach advocated by the upper tribunal is, in my submission, in accordance with the jurisprudence, was not one of total prescription in all cases, but identified what must have been the correct course in this case, faced with an FTT decision which did not consider the statutory tests and impermissibly lowered the public interest in the appellant's deportation. By way of structure, I too will deal firstly with the scheme under Part 5A and the points of principle which can be drawn from the case law, and then we'll turn to the first tier tribunal and then the upper tribunal authorities. looking at what the upper tribunal in fact said, and again, in a little detail, though much less than it had, what it was faced with in the first tier decision, making submissions to the effect that the upper tribunal correctly identified the errors of law and rightly held that they were material, and then deal finally and briefly with the approach this court should take. Just as to the primary and first alleged error, whether the upper tribunal was correct that the first tier should have considered exceptions and the exception 2 in particular as part of the very compelling circumstances test, my submissions will be, firstly, that the approach the upper tribunal took is more careful than has been presented. Secondly, that the need to consider exception 2 in this case arises from the circumstances of this case, namely that this is a serious offender with reasons or material presented on the appeal that were family life, i.e. exception 2 reasons. That the approach the upper tribunal took is supported by the language of 117C subsection 6. It is supported by the case law. And finally, I will submit that the reliance on paragraph 60 of my Lord's judgment in the case of HA Iraq is misplaced. As to the second primary error, that the upper tribunal didn't make an error in my submission in concluding that the FTT had impermissibly lowered the public interest by introducing, as I say it did, a supposed countervailing public interest factor of its own volition. My submission is that the first tier's approach is not in accordance with Parliament's approach to the public interest. It doesn't accord with the jurisprudential interpretation of the statute. And in my submission, there was no scope for the first tier to identify and give weight to a supposed countervailing public interest. And I will deal with the rehabilitation point that was raised by my own friend in that regard. And finally, that my submission is that when one looks at the facts, that is what it did. Turning then first to the scheme, I can be brief. I know that it's well rehearsed before you this morning and in HA Iraq. If I could take you to part 5A, which is at tab 1 of your bundle, the authorities bundle, my lords, my lady. As you know, this part was inserted into the Act in July 2014 by the 2014 Immigration Act to deal with public interest considerations under Article 8. Just confirming the structure at 117A on the first page at subsection 2, you see that in all cases considerations at 117B must be considered, and secondly, in cases concerning the deportation of foreign criminals, the considerations in 117C must be considered. Turning then forward to page 5, where 117C is set out, you weren't taken to, and I'd like to draw your lordships and your ladyships' attention to subsections 1 and 2. The deportation of foreign criminals is in the public interest, and the more serious the offence committed by a foreign criminal, the greater is the public interest in the deportation of the criminal. That is a complete, in my submission, encapsulation of the public interest at play here.
Say it again. What is a complete encapsulation of the public interest?
Subsections 1 and 2, because they confirm, as to the public interest, that the deportation of foreign criminals is in it, and that public interest can increase with the seriousness of the offence. They are supported by a similar statement of principle in the UK Borders Act 2007, which I don't need to take you to, but it's in my skeleton at paragraph 14.
Yep, it says the same thing.
Essentially, yes. The purpose of highlighting this, and I'm going to go to the case law in a moment too, it is not because that is a terribly controversial point, but because there's first a challenge as to whether the first tier in fact took into account an inappropriate public interest, but secondly, if it did, whether that is of any anything that this court should be concerned about. My submission is that it did, but also that it should be concerned about it because the public interest is set out in statute, and matters such as...
Well, I mean, sorry, this always is a problem when you trail submissions. I don't want to engage with them now, wait for you to make them properly. But it's a matter of words, isn't it, to some extent? There's clearly, obviously, this public interest, which is absolutely central to the legislation. But there are countervailing factors, which is also recognised. Some of those countervailing factors could be described as being in the public interest. It's in the public interest that a child with psychological difficulties is properly supported. You can say, yes, well, maybe, but that's not what public interest means in the context of this legislation. But it is ultimately, it's not the sign that you don't understand the structure of the legislation, that you identify some of the countervailing factors as having a public element in them as well as a private element. It's all just got to go into the balancing act, doesn't it?
Well, yes, save that the public interest part of the balancing act is Parliament's attempt to set the public interest element very clearly in one direction and setting out one primary, if not total, public interest. And when one weighs a full balance around that, the other factors are not competing public interests. They are competing Article 8 private life, family life interests that are weighed against the public interest, which is indeed...
You say effectively Article 8 of its character is always private, not public.
Yes, exactly. And the importance of it has been made clear by the Supreme Court in terms of the value to the statutory scheme in KO Nigeria, which is, I won't take your lordships immediately to it, but it's at tab 7 of the bundle. That case provided the first opportunity for the Supreme Court to consider the Part 5A scheme, but it wasn't a decision focused on foreign criminals only, and yet it did consider specifically the meaning of the unduly harsh test at section 117C5, but it wasn't concerned with 117C6. It's important for present purposes because it provided guidance as to the general approach and the purpose of Part 5, and that's at paragraphs 12 to 15 of that judgment. But I'm going to take you to the summary of that which is in HA Iraq, the Supreme Court judgment at tab 5, because it's a little easier and it's all there. That's at page 98 of the authorities bundle. At paragraph 18. I'm happy to read it out for your lordships or let you read it to yourself if you prefer.
Why don't we read it to ourselves?
So could you give me the reference again? Because
Yes, it's tab 5 of the authorities bundle, page 98, paragraph 18, and it is a succinct summary of those purpose and approach observations made by the Supreme Court in KO Nigeria. And draw out two parts in particular. At small 4, that the purpose was to produce a straightforward set of rules which would narrow rather than widen the residual area of discretionary judgment for a court to take into account public interest factors or other factors not directly reflected to the word of the statute. and at 5 that it is appropriate to start from the presumption that the provisions are intended to be consistent with the general principles relating to the best interests of the child, and that, of course, being at the unduly harsh test.
Is that only in relation to the unduly harsh test?
I'm not suggesting it only is, but that is an encapsulation within section 117C at 5. That is part of the scheme, which must be understood as reflecting an understanding of those interests.
Yep. Thank
you. We will come back to this authority, but the authority I would like to take some time on is one my learned friend didn't take you to, which is at tab 9, NA Pakistan.
It's true that he didn't, but it's also true that great chunks of it are cited in the authorities that he did.
I didn't mean it as a criticism,
No, okay.
Merely to pray in aid that I have value in taking you to it. There are parts.
No, I'm sure there are parts.
There are parts I will rely on in a moment, which are not summarised by this court in HA Iraq, and in my submission that's because HA Iraq, when it was before this court, was not considering the case of serious offenders. So those elements, which are the directly applicable ones for the present circumstances, are not given great weight in HA Iraq, and are not. Indeed, the passage the tribunal in this case relied upon is not one that is cited or given any consideration to by this court in HA Iraq, or indeed by the Supreme Court in HA Iraq. So the background to NA Pakistan is that the Court of Appeal here was considering 4 appeals, including a range of different offending backgrounds, both medium and serious offenders. There is a careful interpretation of the legislation which begins at paragraph 11 at page 204 of the bundle.
Just to spell it out, this was actually pre-Part 5A, wasn't it? No.
This is.
No, I'm wrong.
No.
What was I thinking of?
I will take. In fact, this is the very point I'm going to take your lordship to right now. Is to continue to develop.
Forget it. I'm wrong.
Well, I'm going to continue to develop the background public interest point, which I've just been dealing with, because that's first dealt with at paragraphs 11 and 12. And at paragraph 11, they're talking about section 32(4) of the UK Borders Act, which I indicated confirms that the deportation of foreign criminals is conducive to the public good. And they say in the middle of the paragraph, that is a statement of public policy enacted by the legislature, which the courts are obliged to respect. And they go on to say where the dividing line is between being a foreign criminal, and then approve at paragraph 12, SS Nigeria and the Secretary of State, the 2014 case. Lord Justice Laws neatly distilled this principle at paragraph 53, a paragraph with which we agree. And then I'll let your lordships read it. And then if you turn forward to paragraph 22 on page 207, you see that same statement of the importance of the statement of public policy in SS Nigeria being applied, being equally applicable to the new provisions inserted into the 2002 Act by the 2014 Act. And this is the important part at the end of paragraph 22, both the courts and tribunals are obliged to respect the high level of importance with which the legislature attaches to the deportation of foreign criminals. And I flag all this not because it's terribly controversial that the deportation of foreign criminals has a high public interest, but because of what I'm going to say in due course about the public interest side of the balance being narrowed by these provisions, and that's something the courts must accept. and in my submission, the first tier tribunal strayed outside of that by innovating its own public interest and weighing it directly oppositional to the statutorily stated public interest. As to the issues that were in play before the court in NA Pakistan, the court then went on over the next few paragraphs to confirm that under section 11C in the rules, both the exceptions route and the 117C6 very compelling circumstances test, which requires a full balancing act, are available to medium offenders. The initial confusion had been whether the medium offender gets both bites of the cherry or not. So that's what the next passages deal with. And then at paragraph 28, they turn to the very compelling circumstances test and set it out both for the purposes of serious and for medium offenders. And paragraph 30 then, this is one of the paragraphs that was cited later in HA Iraq. I may be wrong about that, actually, I'll double check that, but it's important for our purposes anyway, because it relates to a serious offender.
Yes.
And you see here first the logic of understanding, even for a serious offender, 117C6, by reference to the exceptions as a yardstick, as a practical tool, is starting to be fleshed out, looking for factors identified in the descriptions of exceptions 1 and 2 of an especially compelling kind, going beyond the bare case, and so forth. And having considered their consideration of the the very compelling circumstances test, they conclude at 33 that it inexorably follows from the scheme that sufficiently compelling cases will be rare. Now, this is a point, my lord, the Vice President was keen to emphasise in HA Iraq as showing that whilst under subsection 6, it's going to be rare that there's a positive finding. That isn't the case under subsection 5, which has a lower standard attached to it, even though it is already albeit that it's elevated. When one is dealing then with serious offenders, one is in the ballpark of rare favourable outcomes, and that's something which permeates all of the jurisprudence in this area, that there is a yet higher level at subsection 6. At 35, to continue through the judgment, that's where the court confirms that the Act and the rules together comprise a complete code for the decisions in this area. And then at 36, the court set out the two-stage approach that would be taken in respect of a medium offender. That is, first see if and I believe I use the shorthand from HA Iraq, see if there's a shortcut under the exceptions, and if not, there's a full balance. And in relation to a serious offender, and this is the paragraph at 37 that the upper tribunal relied upon, it's not subjected to consideration in HA Iraq, in the Court of Appeal, nor in the Supreme Court when we come to it in a moment. It is important. I'll let your lordships read it and then make observations.
Yes.
So first one has to understand it comes and follows the two-stage approach for a medium offender. And so even again, it's saying even against the context of you not having to, it will often be sensible to first see whether this case involves circumstances of the kind in the exceptions. But if they do, and that's so that the middle sections talk about why it's sensible to first look, and if they do, you pick that up in the last 4 lines of the paragraph. If they do, it will then be necessary to look to see whether any of the factors falling within exceptions 1 and 2 are of such force, whether by themselves or taken in conjunction with any other relevant factors. So my submission is that this paragraph of NA Pakistan operates something like a funnel, moving from advice.
Something like a what?
Like a funnel.
Funnel.
Moving from advice to expectation. So it's usually sensible to consider if you're serious offender under subsection 6 is making out their case or seeking to make out their case using material within the subject matter scope of exception 1 or exception 2. And if it is, then it is necessary, and the word necessary is there, to look to see how serious they are. And certainly it seems that's how the upper tribunal in this case has interpreted that authority, and in my submission it was right to do so.
So the final moving from advice, i.e. it will often be sensible.
Yes, but it's advice, does it fall within, does the case being presented to you present very compelling circumstances that fall within the scope, the subject matter of either exception 1 or exception 2 or both?
In the great majority of cases it will. It's quite hard to think of any Article 8 cases that don't fall within, the great majority will fall within 1 or 2, won't they?
Yes.
You can have
some may,
cases perhaps don't fall within them, do they?
Some may raise both and need to be
Yeah.
approached on that basis. Some may raise only one, as this case really only raises
Well,
one
that's
of
not
the
quite true.
exceptions.
It's not quite true. It
Well, the
raises
person
both.
has a private life, so yes, but it doesn't. We'll turn to the judgment in terms of whether it complies with the exceptions.
Oh, I see what you mean, yeah.
This isn't a case that complies with exception 1. This is a case where the argument was we comply with exception 2 and more so, and at a sufficiently over and above level to succeed when one looks at everything else around it. So the first logical step is that it's sensible to consider whether you're looking at a case in that subject matter, and if you are, then you use that yardstick of first assessing whether it is, or first considering whether it is
Is the reason why it's only often sensible rather than necessary to go first to the exceptions, so that there will be cases in which it's obviously not a case within either of the exceptions, but in some different subject matter area?
at least theoretically, yes.
Because otherwise one would expect this paragraph to say you need to look to see,
It wouldn't.
and then if you find that the case is within the subject matter territory of one or both of those
Yes,
exceptions,
it may have been
then
that the
you
court
must go on to
was
the-
anxious not to set something prescriptive and unnecessary or prescriptive and unduly extended. It's a sensible tool to first see what subject matter you're dealing with, and if you're dealing with an exception subject matter, then use
Can we
it.
just spell out for ourselves what are the circumstances in which you would have an Article 8, you could have an Article 8 claim which did not fall within exception 1 or exception 2. Let's just remind, exception 1 is about private life.
Yes, but limited. Give me, I've turned to the wrong page now. Limited to the longevity primarily.
Yes. I mean, you could have a case, couldn't you, where someone aged 39 had been living here well, let's take a better example. Someone aged 30 had been living here from the age of 16. So it's not unlike actually the present case. It wouldn't be, of course, that wouldn't have been lawfully resident.
You may find there are cases, in the sense that that Article 8 cases are by their nature richly textured. You may find that there are going to be circumstances where someone says, well, I'm relying on how long I'm there, and I'm relying on it connected to how successful my business empire is and the fact I generate employment, or other features that are just more
in a sense,
textured.
perhaps we can make it. We got to look at Section 1 and Section 2 in order to understand what the court was thinking had in mind in NA Pakistan. But actually, at Section 1, which is not the primary one we're concerned with, is rather more prescriptive.
Yes. Yes.
And it's easier to think of a strong private life case, which for particular reasons doesn't hit one of these, press one of these buttons, but is still a strong case.
Yes.
And Section 2 is much more generally, really only concludes us. You've got to have a qualifying relationship. Well, obviously, otherwise you wouldn't be in Article 8 territory in the first place. And secondly, well, subject to one point I'll come back to. And secondly, really the only test is undue harshness. It requires you to make a value judgment.
Yes, I agree. When one's looking at at an Article 8 case that's brought really on the basis of family life and on the consequences of deportation for the close family members, Exception 2 pretty much encapsulates what a court would be looking at. But
the exception which I had remembered earlier but just forgot when I started this is you can get Article 8 cases with relationships which don't fall within this. You can have elderly parent,
yes,
supportive relationships. You can sometimes, though not usually, as we were discussing earlier, have sibling relationships.
Yes.
Which and those wouldn't fall within Exception 2.
Yes, so you may have any combination of factors or features, but if you're looking at at what you might call one of the classic family life tests, this is going to be bad for my children, then this is the first benchmark test. You've got to pass this by some margin to then be saying, well, now let's gather everything together, including where we've got to on the children, and see whether it's going to be enough.
I see that. We're going into all this only because of my Lord's very pertinent question about why this is framed in the language of advice rather than prescription.
Yes.
And he was saying, is it because you could have other cases which don't fall within Exception 1 or Exception 2?
The answer to that must be yes, you can, and also that there is a distinction to draw when one is describing the statutory language between a medium offender where the Court of Appeal was going to be saying to the tribunals, you must go through this process, and a serious offender where they're going to be saying, well, look first and see if it's one that engages it, but if it does, it is necessary to look at how, by what margin.
But the problem perhaps with that analysis is that even so, I mean, Lord Justice Yalcin says why it's sensible. It's because Exception 1 and Exception 2 set out particularly significant factors on bearing on respect for private life and family life, at any rate in the typical cases.
Yes.
And because that, presumably the setting out of those factors, may provide a helpful basis on which an assessment can be made.
Yes, but it has to be...
That does suggest that he's really only advisory. I mean, I see the common sense of it, and speaking myself, I fully agree with it, but it is advisory, it's not a rule of law.
Well, there's two points to make about that. Firstly, it's advisory in its first part. It is, in my submissions, prescriptive in its final passage.
Yeah, but if you choose not to take the advice, then you don't get
and
to
you
the
don't
second
get there.
part.
Well, I do accept the difficulty there in terms of asking a tribunal to follow it. But the other aspect of that is really whether whether what was required here and what is required here, and Mr. Malone Friend's submission which he made, is that there's no requirement in law to make definitive findings on the exceptions. And my submission is that's not what this is saying is required, and it's not on a fair reading what the upper tribunal was saying. It was giving guidance to a first tier about how to do it well, and we'll come to that in a moment. I see your ladyship, and I want to reassure you I will come to those points. But
I see the time, by the way. Was that
Yes.
what you meant? Yes, sorry.
that's it. And
It
I'll
is because I was grasping for the judgment to see whether I.
Oh, I see. Yes, right. Well, if there's a point you want to finish off, let's finish it off. Otherwise, if that's a good point, we'll.
That's the final point in respect of NA Pakistan is connected to that, and that is that one must read that funnel paragraph at 37 alongside paragraph 30, where it deals with the fair case versus the goes beyond case that's required for a serious offender. That one informs the other when considering that analytical tool of looking first at the subject matter and then how one deals with it if the subject matter is engaged. That takes me to the end of that particular authority.
Thank you very much indeed. Well, we'll resume at 2. It would be helpful if the two of you could just liaise about the various factual queries. I mean, one thing I perhaps didn't quite spell out, but I think I hope it was implicit, is it would be quite useful to know, just as background really, which authorities were before the first tribunal,
Yes.
whether cited by Mr. Acharia, if I'm pronouncing him correctly, or by the presenting officer, whose name I forgot.
Certainly for my part, I know digging has been going on behind me, including internal inquiries for the skeleton argument, which would be the best source of that. It may be that it's something we have to provide a short note to your lordships on after the hearing. I don't know, but I'll see what I can find out over lunchtime.
Yes, I mean, it is often the case in these cases with puzzling bits in a first-tier tribunal decision. Sometimes it becomes a lot clearer when you see how the arguments were presented. And so if there were skeleton arguments, which I just assumed there weren't, or I thought...
we haven't found one yet, so
no,
I don't mean to imply
no,
that
there often aren't, but if there were, it would be quite
Yes.
useful to see what they were. 2 o'clock.
Otherwise, if you're able to.